Yeah, so why do you think that the Chief Justice is deliberately recommending some of these judges to the Supreme Court to pack up the place so that in case the NPP, loses or wins the elections, they can still defend them? What exactly is that about?
Well, by her actions. This whole issue about justices of the Supreme Court has been a matter of debate for a very long time. And Professor Mills established the Constitutional Review Committee. Was there a commission or a committee? Yes, whatever it is. They presented their report. And
so it was a committee?
Yes. They dealt with the issue of the number of Supreme Court justices, whether we have to put a cap on it or not. And so the report is there. During President Mohammed's time, when the implementation committee was set up, somebody sent it to the Supreme Court. By the time the court gave the green light, the NDC was almost out of office. It's been 8 years, and NPP has not said anything about this Constitutional Review report. I think that if we want to deal with issues in the judiciary, we must comprehensively address it. The issue about justices on cases or the composition of the Supreme Court is not the only constitutional debate that has come up with respect to the judiciary. And so to pick one of it and justify it, and for the Chief Justice to go ahead and suggest names or even submit a list for appointment, I sincerely think that there's some collision between the executive and the office of the Chief Justice. This one I will not say the judiciary, the office of the Chief Justice, to pack the Supreme Court. Because I was following the case of Dr. Opuni and Agongo when they went for an appeal at the Supreme Court. When the case was ongoing and the justices have received the submission of the cases of both the defendant or the applicant and the defendant or the respondent. And just as they thought that they were going to give a ruling, the Chief Justice changed some of the justices and then recomposed that panel. It did not tell me that this is a court that has overload of cases. It rather told me that, there's virtually no work to be done, so let's allow everybody to take part in cases that are ongoing. And so for the Chief Justice to come back to say that there are a lot of cases and so they need many justices to sit on them and give a justification for keeping 20 justices of the Supreme Court. And does not even end there. She goes ahead to nominate the numbers that will make up for the 20 that she has justified for. That should tell you that there is some kind of conspiracy going on. Her justification for the 20 justices at the Supreme Court has been exposed by her appointment or her suggestion to the president to appoint some new justices in order to make up the numbers. So it meant that when she was writing to the president to justify for 20 justices of the Supreme Court, she already had in mind some persons that she wanted to take to the Supreme Court, which means that if she had 10 in mind, she would have justified for 25 to be the upper limit by convention. And for me, that act by the Chief Justice is unconstitutional. And when people conduct themselves contrary to the provisions of the Constitution, there must be consequences for that. And people have suffered for it. There are persons who have been elected members of parliament, and by virtue of the fact that the court believed that by putting themselves up for elections, they had offended the Constitution. Even before the final determination of the matter, these persons were injuncted. They were not allowed to perform their parliamentary duties. And so if the Chief Justice, who is like the chairman or the president of the Supreme Court, does an act which offends the Constitution, I think that it must not be left at that. The Constitution is very clear. If you look at the provisions on the composition of the Supreme Court and the appointment to the Supreme Court, Article, I believe, 144, it's very clear. 2 institutions involved. The Judicial Council, 3 institutions. The Judicial Council, the Council of State, the Parliament, and 1 person, the President. The Chief Justice has no place in the process, except for the fact that she is a member of the Judicial Council.
But if, for example, the Attorney General has written on this, and he thinks that she's not done anything unconstitutional, especially if she's asking for an increase in number because there's an influx of cases. She says that the Supreme Court hears about 45 cases weekly and 180 monthly, and the court is unable to conclude 80% of cases filed and those pending at the beginning of the year. Only 37% of such cases are completed. In fact, in 2022 and 2023, she says only 37% of the cases were completed, and then 44% of those were concluded in 2021 and 2022, which is why she's asking for an increase.
Can we know that of the High Court?
Well, she didn't give those details,
okay,
and I don't have that. But these are the reasons why she's asking for an increase in the number. The Attorney General has also penned his idea, and he says that having regard to the relevant provisions of the Constitution, the determination of the number of justices of the Supreme Court at any point in time would be a function of the administration of justice and the needs for court. Given the breadth of the multiplicity of jurisdictions of the Supreme Court and the influx of cases at the Supreme Court, the request for the increase in the number of justices serving on the Supreme Court from the conventional 15 to 20 is not only constitutional, but would ensure speedy and effective justice and minimize delays. So the Attorney General agrees.
Yes, that's why I'm telling you there's a coalition. There's a coalition. Because this justification cannot hold if you look at the entire hierarchy of our judicial system. Go to the circuit court. Do you know the number of cases there? The High Court, even the Court of Appeal. This is a Chief Justice who has closed down various Court of Appeal and left only council. Help me. I think it's only Kumasi and Accra left.
I think so.
Yes, she closed down Court of Appeal. Do you know the number of cases at the Court of Appeal? And so please, they should not try to justify this unconstitutional act.
Okay.
For me, it was just an attempt to aid the president to pack the court. Simpliciter. Okay. This is a president who has appointed the most number of justices at the court in the entire history of this country. And the way they do it, it is as if there's a scheme to look out for people who may be going on retirement, put them there a year or two. When they are out, the president has another opportunity to still move people there. And so they should spare us the justifications. We can see through it.
Well, the Ghana Bar Association
was clearly to pack the court, it is unconstitutional and must not be countenanced. I
don't think the Ghana Bar Association necessarily agrees with you, because they have also released a statement where they said that in principle they agree with the request of the Chief Justice. Xavier Kuje is a PRO for the Ghana Bar Association. He joins us via phone. Good morning, sir.
Good morning, my sister. How are you?
I'm fine, thank you. How are you doing as well?
I'm also fine.
Sorry for keeping you waiting for long, but
that's okay. Just to, I don't know who's on the other side of the line, but let me correct this impression. The original Court of Appeal sittings were not stopped by the current Chief Justice. This happened under the immediate past.
Okay.
I think let's get that clear. She's rather trying to bring them back.
Okay. Thank you for that correction. But if you say that you agree with her request in principle, what exactly does that mean?
Yeah, what it means is that the Constitution, what it means is that the request, there's nothing wrong with the request as far as we are concerned, because the brief that we received from the President, that is the one the Chief Justice sent to the President in making the request. is giving statistical analysis of the workload at the Supreme Court. Based on that, we had agreed in principle, saying that if that is it, because we have always operated with a conventional number, and the Supreme Court, the Constitution only set a minimum of justices for us, 9, with the Chief Justice making 10. That makes the Supreme Court. But over time, we realized that we have to move up. So we've been doing 16, 15. Today we have 15. So if there's really evidence of workload at the Supreme Court, and that for that matter, we'll have to revise the conventional number from 15 to 20, then there's nothing wrong with it. But conversation must be had with other stakeholders such as Council of State and Parliament. We even went ahead to say that to further do us a lot of good, the Supreme Court should be automated so that proceedings there can be recorded live, because it appears the judges are writing longhand every time. And we also said that various judges should be given libraries and research assistants well trained so that to facilitate the process, so that research will be done for them. They just to write their rulings and judgments. So we don't see anything wrong with the request. I believe what is bringing all this problem is the approach of the Chief Justice nominating some people.
Okay.
It is true. The judiciary headed by the Chief Justice is one of the parties that must propose names for appointment or make nominations for appointment. The Ghana Bar Association is another body, and the Office of the Attorney General. When these three bodies put their list together, they send the list to the Judicial Council. It's the Judicial Council that will vet them, screen them. If there's a need to drop some, they will drop. And based on the available vacancies, they will now forward the list, advising the president to make the appointment. This advice is not binding on the president. The president can reject everybody on the list, or he can decide to choose some and leave some, or he can say that, as I said, reject. But once he does that, it doesn't mean that he also has the right or the power to prepare his own list. You have to refer to the Judicial Council for the whole process to begin. So that is the way it is done. So I must admit the Chief Justice made a mistake by writing directly to the president proposing such a list.
So from what you're saying, she breached the Constitution, basically.
For me, I see it as an irregularity because there's an argument that because of this...
What's the difference? I'm trying to understand. What's the difference between an irregularity and breaching the Constitution that says that the right thing to be done is for the president to now go to, the Judicial Council, and then they will proffer advice before he goes to Parliament?
Well, has the act been carried out? It's not been carried out. It's in the process. You see, that couldn't have even been done because nominations are supposed to be made by the bar. We haven't done it. By the AG, we haven't done that. So I think that's why I say her letter should have gone to the Judicial Council and not the president. Okay, and we make mistakes.
So that's a breach then.
We are hanging on to this for far too long. It's not as if she's insisting I'm right, I'm pushing it. She hasn't said that.
So that is a breach, sir. So that is a breach. Because for a Chief Justice who's supposed to uphold the Constitution of the land, she holds the highest office, to go against what the Constitution says. Clearly, she's breached the Constitution, no?
My sister, I have admitted it is an irregularity on her, but she didn't act within the
Are you being economical with the truth?
What I'm saying is this. We all make mistakes. You are a lady. You may be cooking. You have ingredients. You may forget one. But at the time that you should put it in, you don't put it. Later, you come and put it in your recipe that you are preparing, whether it's a soup or it's a stew or what have you. So what I'm saying is that nobody is justifying the procedure adopted by the Chief Justice. What we're saying is that the request is excellent, but the procedure adopted by her, by writing to the president of suggesting is wrong, because she should have suggested those things to the Judicial Council, which is the part of, she's actually the chairperson of that council.
Okay. It's interesting that you related to cooking. I mean, we're talking about, having judges at the Supreme Court. I don't know how we can relate it to making a mistake in the kitchen at all, especially when it has to do with the Chief Justice. But in that case, can you also agree to the fact that is there enough evidence to show we really need a minimum of 20 judges at the Supreme Court?
Yes, I'm privy to the statistics.
Okay.
And I think that we need them, but the timing is what I'm concerned about. I don't think that we can do this today and this year, because come 31st July, the courts are going on recess. You resume in the middle of October. I am not sure the numbers that we have as backlog. These additional 5 judges can clear them within a short time. So let's do a lot more consultation and put this into maybe next year or some other time. As for the request, it's excellent. We agree because we have evidence of the success.
Okay.
We agree to that, yes.
All right. Well, Xavier, thank you so much for joining me. I'm very grateful for your time. Xavier Kuje is a PRO for the Ghana Bar Association.
30 seconds.
Please allow. No, we don't have time.
Seconds. No, just 30
we don't
seconds.
have time. So
I just
let
want
him
to
have his. Let him have his time, and then if there's extra time, I'll give it to you. But allow him because I'm already being told my time is at council.
In fact, I don't see the confusion in this matter. I think it's pretty straightforward. The CJ purportedly wrote a letter to the president proposing some names. The question is, does she have the power or does she not have the power? Yeah, you understand. It's pretty clear. She has breached the constitution. See, there's no other way of looking at this. You see, and a good morning, my brother Xavier. Xavier is my very good friend. You see, I know the Judicial Council in their doing their job of advising the president will certainly have their own internal procedures. Yeah, understand. And so, because we should understand that the Judicial Council has reps from the GBA, from all the various courts, and all. That's the internal issue. But the point is simple. Does the CJ have the power to write the letter that she has breached the constitution, whether it's an irregularity, whatever it is? She has simply breached the constitution. For me, it is worrying. It is worrying because, I was talking about a lack of credibility in leadership. You understand? And in governance, perception is everything. Indeed, in granting or in giving justice, perception is also critical. And that's why we say that justice must not only be done, but it must manifestly be seen to be done. When we say must manifestly be seen to be done, then we are talking about the perception here. So immediately, it was already there's a perception that the president, for whatever reason, is packing the court. Where the CJ herself, you understand, writes letters that she simply does not have the powers to write, and propose 5 extra justices, you understand, in this jurisdiction. I don't know what the numbers say, but how can you justify where a country of about 34 million people have right now 15 judges and want to have 20 Supreme Court justices?
But she has given reasons why. There's still a backlog of cases from 2021 and 2022.
You understand? How can you justify where a country like the USA, where they are more, as in there's certainly more litigation than in Ghana here, they have just 9 Supreme Court justices.
But they have about 395 or so across the states in totality.
No. Listen, they are not.
So she says that you cannot even do that comparison.
They are not.
They are not. Comparison.
No, they are not. You see, let's understand that in the US we have the federal, and the CJ and the Supreme Court deals with the federal issues. Bella, do you know the number of issues that their Supreme Court has to deal with? Yeah. We shouldn't.
But the Supreme Court has the power to decide on which cases they would want to sit on, because most of the other cases are taken care of by the Supreme Court judges in the federal states.
Bella, in Ghana here, beyond constitutional cases, beyond second appellate court cases, beyond review cases, which rarely happen. How many cases do they handle? We shouldn't do this to ourselves. Because also in the US, all the Supreme Court justices sit on every single case that comes there. In the US, in Ghana, they don't sit on, because of their numbers, they don't sit on. The CJ has that discretion of picking and choosing who to. You understand? I think that fact also needs to be made known. Now in the US, when you're a Supreme Court judge, you sit on every single case. They do not choose. So why? So we can have an argument on the reasons, whether or not there is a reason why we should have more than 15 or even 9 Supreme Court judges. But for me, at the end of the day, we need to accept, and the Ghana Bar Association needs to accept. It's not a matter of an irregularity. The CJ simply breached the constitution when she wrote that letter, because she does not have that power. That power is the sole prerogative of the Judicial Council. It's their duty, their power to advise the president on matters concerning appointments onto the Supreme Court. And I think that is pretty clear as to whether then 15 to 20 is just, that's a number that an issue that we can debate. But as things stands now, per our constitution, there's no cap on, you understand? And for me, it calls for massive or an immediate reform.
Okay.
But on the issue of whether or not what the CJ did was constitutional or not, is clear.
Right.
The CJ used powers that she simply does not have.
All right. Well, time is about. You said 30 seconds.
Yes.
I can give you 10.
Okay, no problem. I think that Xavier was just trying to defend the Chief Justice. He says the Chief Justice breached procedure. What procedure?
Which says it was an irregular.
No, what procedure? He initially said she breached procedure. What procedure? The constitutional procedure. And so it's a clear breach of the Constitution. Second, he says that the act was not carried out. What does he mean when he says the act was not carried out? The Chief Justice wrote the letter. The President acted on the letter and made the appointment. It was only stopped at the Judicial Council. So the act had already taken place. And so please, let us not try to, you GBA raise this issue at the Judicial Council. Why are you now in the public attempting to defend the and secondly, the Court of Appeal in the regions have been closed down. Many of them have been closed down. As to whether it is this Chief Justice or the other Chief Justice, it has been closed down.
All right.
So that office that closes Court of Appeal cannot justify more appointment to the Supreme Court.
It's just one sentence.
One sentence.
To say that the Judicial Council does not agree with this call to increase the numbers because their reason for refusal is that they feel that it was wrong for the Supreme Court to be backed by the President. I think that's
These are 7 sentences in one. But anyway, Wilberforce Ogwa says, so the PRO is saying the Chief Justice can utterly make mistakes on something that has got to do with the laws and regulations of a country, and it should be seen as okay. This is not good. The country is being led by a non-conformer of laws and order. Everyone in this government is a non-conformer, and they do whatever they want. Okay, they want to bankrupt Ghana, Sachi Mo. Okay, thank you for your message. So these are some of the mistakes that the CJ and the judges always make that lands innocent souls in prison. They behave like they are God, and they are infallible. I know there is fire hanging in the sky. We beg you. Okay, how can you understand 24/7 economy when review means cancel to your party? I'm not sure what you mean by that. But we will be heading to the Ashanti region, and ahead of the official outdooring of Dr. Matthew Opoku Prempeh as the running mate for Dr. Mahmoud Bawumia, our team is on the ground. We'll be bringing you the community manifesto, a very unique edition of that with our correspondents on the ground who will be speaking to some of the people who live in the Ashanti region to tell us what they make of the situation so far and whether they are happy or not about the unveiling of Dr. Matthew Opoku Prempeh. This is TV3Newday. Thank you so much, gentlemen, for joining me. I've been speaking to Mr. Broja Jemfi. He is the Deputy Director for Special Duties with the NDC. Andrew Apia Dankwa Esquire is a private legal practitioner, a member of Butterfly Nation, I like to say. He's a team member of the Communications for Movements for Change. And earlier we had Musa Dankwa join us from Global Info Analytics as the Executive Director, and Xavier Kuje, the PRO for the Ghana Bar Association. Just a reminder, we're cashing out *439#. Select option 2. But remember, you have to be a Telecel subscriber or an MTN subscriber to play this game. We're giving out 1,000 Ghana cedis to 4 of our viewers this morning. You could be one of the winners. Please play as many times as possible. When we get back, we have sports and then we have Community Manifesto. Don't go anywhere.